Honored guests, my name is Lionel Smith, and as the director of the Cambridge Private Law Center, it's my pleasure to welcome all of you to the Cambridge Law Faculty on this wintry March day, and to welcome you to the 2023 installment of the Cambridge Freshfields Law Lecture. As you know, Lord Sales, a Justice of the Supreme Court of the United Kingdom, will speak to us under the title Constitutional Values in the Common Law of Obligations. I will not actually introduce Lord Sales. That role will fall to Professor Pippa Rogerson, Master of Keys, who is my colleague twice over in the Faculty of Law and in the college. But with her permission and that of Lord Sales, and yours as well, I hope, I will speak for a few minutes before passing the floor to Pippa. The Cambridge Freshfields Law Lecture is the flagship event of the Cambridge Private Law Center. And so it's always an important occasion for the center and one upon which we can thank the firm of Freshfields Bruckhaus Deringer for its generous support over many years. I was expecting a delegation from Freshfields, and I'm, to be honest, not sure whether they've arrived yet or not. But let's hope that if not, that they will soon. I think the weather has slowed some of the trains down. This year's lecture, however, is particularly significant, and this is because it gives us an opportunity to mark the 10th anniversary of the Cambridge Private Law Center. I have a few slides to help celebrate these 10 years of private law scholarship, and I thank my colleague Nick McBride for helping me to put these images together. The center was created in 2012, originally under the co-direction of Professor Graham Virgo, who will be thanking Lord Sales later this evening, and Professor Sarah Worthington, who unfortunately was not able to be with us today. The first public event of the center was in May 2012. It was a debate here in the law faculty between Lord Peter Millett and his son, Richard Millett, KC, on the question whether or not a fiduciary who receives a bribe holds it on trust for his or her principal. That issue was later resolved by the Supreme Court in favor of the trust, as we all know, and thus correctly. And if you look very closely at this image, you might see that a much younger Canadian law professor was present on that day just over 10 years ago. Since 2014, the center has been hosting the Cambridge Freshfields Law Lecture with such distinguished speakers as Lord Neuberger, Lord Hoffman, Lady Hale, Steve Smith, and most recently, Dame Sarah Falk. Although we are here again today for the next installment of the Freshfields Lecture, I wanted to take a moment to give you a sense of how much the center has done in private law over those 10 years, for much of that time, primarily under Sarah Worthington's leadership. The center has organized or participated in multiple conferences which have generated important volumes of scholarship, addressing a very wide range of subjects, including commercial remedies, the relationship between law and equity, private international law, the law of succession, land registration, and other fields, including through some of these volumes in the well-known Landmark Cases series. Members of the center have promulgated important new thinking in other ways, including the series of Clarendon lectures that were given by Professor Jane Stapleton, and also the book series on key issues, key ideas, which includes now volumes on tort law, contract law, commercial law, and a sneak preview, not published yet, trust law. This is not all, as Cambridge jurists have also published important monographs across a whole range of private law fields, some of which you can see here. Moreover, textbooks for both practitioners and students on every aspect of private law. So I end here with a few images of conference events, including the International Biannual Conference on Obligations that was held here in 2016. Because to me, the best thing about a research center is bringing people together to debate and discuss ideas, as indeed we will do today. Looking back on the extraordinary work and leadership of my predecessors in the role of directing the center for the last 10 years, in conclusion, I would like to say two things. All these events and all of this extraordinary scholarship reminds us that fundamental private law plays a crucial role in our social order. It's the law's understanding of how we rightly live our lives together. This is why so much of the compulsory core of a legal education is made up of private law subjects. And it is also why legal practitioners who put together extraordinarily complicated transactions also need to start from private law, because fundamental private law provides the molecular building blocks from which such complex intellectual constructs can be built to accomplish their objectives and to last. And the second thing is to repeat my expression of gratitude to Freshfields. Lord Gough of Chieveley once said that academic lawyers and judges were both, I quote, pilgrims on the endless road to unattainable perfection, end of quote. I don't know whether that's inspiring or a little bit discouraging. But I'll finish by saying with gratitude that Freshfields have steadfastly supported the center as it pursues its mission of supporting everyone who travels along the road of improving private law and our understanding of it. And with that, I will hand the floor to Pippa.
Well, good evening, and Lionel, thank you for that. I would like to add my thanks to Freshfields for their generous contributions towards this lecture over many years. I think I have been to every single one, and I've learnt a lot, and it has been enormously interesting. But it's my great pleasure this evening to be able to introduce Lord Sales, Philip, who will shortly be both enlightening and entertaining us with his lecture, the title of which is on the screen, Constitutional Values and the Common Law of Obligations. So marrying both private and public law interests, which our speaker manages so well. I'm very much looking forward to it. Lord Sales is one of Cambridge Law Faculty's most stellar alumni. What is higher than the Supreme Court? In particular, to be the youngest member of that court, not only on your appointment in 2019, but still the youngest, 4 years later, and 6 further justices. I suspect, given the nature of the court, you might be holding that position for a few years yet. Philip started at Cambridge at Churchill in 1980. It was a very good vintage. He graduated as one of a very strong group in the first class, but he was not top. That accolade goes to another bright star, Dame Sarah Falk, of which we've heard, because she gave last year's lecture and was a partner at Freshfields before she became a judge and is now in the Court of Appeal. But along with Sarah in that graduating class were some Cambridge Law Faculty professors here now, although not this evening, I think, Professor Eilish Ferran, Professor Simon Deakin, Richard Hooley, Roger Jindal, who was another Freshfields partner, and as it happens, me. So that, I think, is about 7 or 8 of us in the 30 that were in the first class that year. Obviously, the examiners had been drinking something very good. 1983 feels all of 40 years ago. For the students here, I was not sitting in this building, actually, but sitting over in the old school swatting for my finals at this time 40 years ago, as indeed, I suspect, was Philip. But look at us now, and specifically, let's look at Philip. He left Cambridge to take the BCL at Oxford, at Worcester, then went to the bar, 11 King's Bench Walk, in which you had a mixed practice. It's Derry Owen's old set, both in public law and private law, before becoming the Treasury Devil in 1997, although I gather we're not supposed to call you Treasury Devils anymore. That's what I was told when I was reading the court's website. To the High Court in 2008, so that's pretty speedy. Speedily into the Court of Appeal in 2014, before becoming a member of the Supreme Court in 2019. Since 2019, Westlaw tells me, Lord Sales, that you have been involved in 195 judgments. I could go through them all, but I'm sad I didn't have time, and indeed we wouldn't have time to hear much more interestingly from Lord Sales himself this evening. So, Philip, thank you. Thank you for agreeing to give this lecture. I understand that you're prepared to speak for about 45 minutes and then to take comments and questions afterwards before we go to drinks in the foyer, to which everyone is very much welcome. We're very eager to hear your views. I know it's going to be fascinating. Thank you.
Thank you very much, Pippa. Well, I'm honoured to have been invited to give the Cambridge Freshfields Annual Law Lecture for 2023. I'm grateful to Lionel for asking me, and I wish him all the best for the next decade and beyond of the work of the Cambridge Private Law Centre. A broad range of topics has been covered in past Freshfields lectures across the legal spectrum. I've picked a topic which brings together values typically associated in the modern legal map with public law on the one hand, and on the other, the private law of obligations within the common law. Now, constitutional values is a term which appears to relate to concepts of what we would now call public law. By constitutional values, I mean the basic rights and interests which structure relations between the individual and the state and the obligations to which they give rise, which underlie the common law and to which it gives recognition in more or less articulated forms. These are rights and interests such as liberty, private life, freedom of expression, and access to justice. They sound much like human rights, you might think, and you would be right. Constitutional values and human rights overlap, but they are not necessarily and always the same, either in content or in effect. At times I use the terms constitutional values and human rights more or less interchangeably, and at others I will differentiate between them. The term human rights comes with certain connotations. It can suggest that the values represented in human rights are new, inventions of the Universal Declaration of Human Rights of 1948 or of the European Convention of Human Rights of 1950, which has furnished the rights being brought home in the form of obligations placed on public authorities under the Human Rights Act of 1998. As I will show, this is a picture which can be misleading as regards the constitutional values and protections inherent in the common law. They were an aspect of the common law of obligations and so featured in the area of what we might now designate as private law. In exploring this, I hope to retrieve and bring to the surface an important aspect of the common law in terms of both private law and public law. Indeed, I will suggest that in the common law, this distinction is not all it seems. What we now call public law and private law grew up together, and to a large degree, private law reflected and continues to reflect what we now think of as public law values. But English law has seen a process of increasing differentiation between public law and private law, which tracks the growth of the reach and power of the administrative state. I will try to explain how this process of differentiation has had implications for the role that constitutional values play in the common law of obligations. I will do this by looking at three phases of the common law: the period before the making of the European Convention of 1950, the period between the ratification of the Convention and the coming into force of the Human Rights Act, and the period since the Act came into force. In the first phase, constitutional values were taken to be inherent in the common law of obligations. In the second phase, there was a growing sense of constitutional values in the form of human rights set out in the Convention as providing a vantage point external to the common law, which might have something to say about how the common law should develop. In the third phase, under the Human Rights Act, there is a statutory obligation for courts to give effect to the Convention rights, and this has focused minds more directly on the Convention rights as concepts external to the common law, which express values now to be injected into the common law, and how that radiating effect should be conceived and managed. Through the prism of this constitutional framing, I will explore the conception of constitutional rights and values in English law by comparison with the view of them in German constitutional law. I will seek to trace the differences in these constitutional perspectives through the case law of the European Court of Human Rights in Strasbourg, particularly as the Strasbourg case law has developed in relation to what are called positive obligations under the European Convention. This journey then brings me back home to domestic jurisprudence under the Human Rights Act. And finally, placed in this historical context, I will consider the modern-day impact of constitutional values on the common law of obligations. But first, let me start at the beginning. Human rights is a modern term, but the values which they reflect are not. I want to start by considering the history of constitutional values in the common law prior to the drafting and ratification of the European Convention. The common law has always reflected constitutional values, but the common law is ancient, and those values have changed over time. In his lectures published in 1908 as the Constitutional History of England, Maitland provided a series of snapshots of constitutional law at different points in history. The first was a snapshot of English public law at the death of Edward I. This contained a substantial section on land law. As Maitland explained, under the feudal system, the great part of public rights and duties were inextricably interwoven with the tenure of land, so that the whole governmental system was part of the law of private property. However, the long-standing roots of modern constitutional values in the common law tradition can also be seen emerging before this in the Magna Carta of 1215. Chapter 29 stated that, "No free man shall be taken, imprisoned, or disseised of his freehold, or liberties, or free customs, or outlawed, exiled, or in any way destroyed, nor will we proceed against him, save by the lawful judgment of his peers, or by the law of the land. We shall not sell, deny, or delay to any man right or justice." These are concepts familiar to us, although their content and significance has changed in modern times. We can see, articulated in the 13th century, the right to security of the person, the right to a fair trial, the principle of no punishment without law, and the protection of property or possessions by law. In the 17th century, Sir Edward Coke championed Magna Carta as the epitome of rights recognized by the common law. Linda Colley has described how in the 18th century, a cult developed around Magna Carta as a foundational text that sustained Britain's constitution, including in the writing of William Blackstone. These foundational rights are reflected in any charter of rights in legal systems today. Dicey, in his seminal text on the UK Constitution, lists 3 substantive rights which have constitutional status as aspects of the principle of the rule of law. First, the right to personal freedom, particularly as protected by the courts by the writ of habeas corpus. Second, the right to freedom of discussion. And third, the right of public meeting. These rights were exercisable in private law. Speaking of the right to personal freedom, Dicey emphasized the strict adherence of the judges to a principle which underlies, quotes, "the whole of the law of the Constitution and the maintenance of which has gone a great way both to ensure the supremacy of the law of the land and ultimately to curb the arbitrariness of the Crown, namely, that every wrongdoer is individually responsible for every unlawful or wrongful act in which he takes part and cannot plead that he did it to comply with orders from a superior." The drafting of the European Convention in 1950 was not, therefore, an exercise of pure creation. There was much in terms of an understanding of English law for the drafters to work with. It is recognised that British lawyers were closely involved in the drafting. The substance, if not the form, of the rights they went on to articulate was largely familiar and established. Much of it, indeed, would have seemed familiar even to an English lawyer in the Renaissance period. In the common law, constitutional values were not regarded as part of a distinct domain of public law. The very notion of public law is a latecomer in English law and is to some degree alien to it. It emerges and gathers force with a sense of the need to provide legal parameters for the operation of the burgeoning administrative state in the course of the 20th century. But it had to overcome resistance arising from three things. First, the basic idea inherent in the common law tradition, as encapsulated by Dicey, that the same ordinary law applies to individuals and officials. Differential treatment for those acting in a public capacity merely by virtue of their public status has been resisted, and there was no general principle of executive right or privilege. Secondly, the absence of a developed idea of the state as distinct from the essentially medieval idea of the crown. And thirdly, the absence of a dedicated institutional home in which public law could be developed in the form of a specialized system of administrative justice, such as existed in France. However, in the study and practice of law today, we've become accustomed to the conventional distinction between public and private law. Pippa used that terminology when introducing the lecture. The former focuses on the limits of state power in relation to the individual. The latter governs legal relationships between private persons. From there, we're also familiar with the conceptual distinction between the vertical and horizontal nature of legal relationships. Public law is framed as vertical, involving the exercise of power from high to low, from the state to the individual. Private law is framed as horizontal, involving legal relationships between two private parties of equal legal standing. Unlike constitutional values, as they emerged in the historic development of the common law, the public-private divide and the vertical-horizontal distinction reflect a modern way of looking at the world, and in particular, of looking at the state as an entity distinct from civil society. The famous illustration of the Dicey analysis is, of course, Entick and Carrington from 1765. This established that public authorities had no special powers to override private rights, but were in the same position as ordinary private individuals. If they violated private rights, they would be liable in law as tortfeasors, unless they could show they had statutory authority for what they had done. This basic position has continued relevance in contemporary law. In M and the Home Office in 1994, for example, the House of Lords held by application of such foundational principles that the court retained a jurisdiction to grant injunctions against ministers and other officers of the Crown. A minister could be held to be personally liable in contempt for breach of such an order and did not enjoy special protections or privileges by virtue of his position. Dicey emphasized and reinforced an historical resistance of the common law to a droit public, a body of law on the French model, which confers special status and powers on government officials. The common law does not accept that those acting in a public capacity have different powers than ordinary individuals to interfere with private rights. What we would now think of as a modern form of public law remained without recognition until the accelerating demands of the modern administrative state pulled it into existence. Before that happened, the axis of the common law tended to remain horizontal so that constitutional values were reflected in private law. Why might that be? I suggest that the answer is in the historical context of historical values in the common law. Modern public law has two dimensions. First, the control of public power to ensure it is used for the public good. And secondly, the protection of individuals against arbitrary use of power in relation to them by the state through individual rights, extending from historic due process rights of natural justice to modern substantive rights in the form of human rights. The second dimension is framed as endowing the individual with rights to resist the excesses of state power as applied to them. As is now very familiar, in the application of human rights, the potential conflict between individual rights and the public interest is resolved through a proportionality balancing exercise. That framing suggests that these competing rights and interests meet in that exercise for the first time, that they are of different origin and are of a different nature, and now fall to be brought into some form of harmony or accommodation through that exercise. But from the perspective of the common law, this is a rather distorted picture. Far from being newcomers, constitutional values have deep-rooted foundations in the common law. They are already present in the way the law has come to be articulated. Absorbed into the common law tradition, that tradition has already produced a resolution of competing values. The law in Entick and Carrington is not the product of, nor is it dependent on, some form of proportionality balancing. It is the product of more fundamental conceptions of rights at common law, operating essentially on the horizontal plane. That history has consequences for the debate as to the impact of constitutional values on the private law of obligations, and the extent to which values which are now conceived of in terms of public law may radiate into private law. If private law already accommodates those values, the extent to which public law, as currently conceived, can inject new content into the law of obligations may well be limited. I will now move from the historic position of the common law up to the middle of the 20th century in the making of the European Convention, to the position following the ratification of the Convention, but prior to the coming into force of the Human Rights Act. The United Kingdom was heavily involved in the creation of the Convention. The UK was the first country to ratify it, and Lord McNair was the first president of the Strasbourg Court. The Convention was, to a significant extent, a UK invention, designed to internationalise the constitutional values, or human rights, which British subjects had long enjoyed. Whilst the adoption of the European Convention was of great significance for many reasons, an English common lawyer would not have considered there to be anything surprising in the rights themselves. They were taken to be a reflection of the existing, long-standing constitutional values inherent in the common law. It was not therefore anticipated that the adoption of the Convention would challenge the operation of English law itself, except perhaps in the colonies. The whole affair was treated as a matter of international relations, rather than considered to be a matter affecting domestic jurisprudence. However, the creation of a new institution in the form of the Strasbourg Court, which was dedicated to expounding and applying the Convention rights, came to have major significance, especially after the extension of the right of application by individuals. After a rather slow start, the court came to develop a detailed and sophisticated body of human rights law binding states. This was a court dedicated to the development of a specialized form of public law. The significance of this institution as the engine of new doctrine tailored to the modern state was as great as that of the French Conseil d'État as the institutional engine for doctrinal development of a specialized public law in France. Whilst during this period, the UK courts were under no domestic law obligation to follow or comply with the rights set out in the Convention and the Strasbourg case law, they came gradually to be aware of an overlap between domestic law and Convention law. Whilst not bound to follow the decisions of the Strasbourg Court, the belief was that the common law reflected the values it was expounding anyway. Convention rights were therefore referred to in domestic case law, albeit predominantly only in a fairly abstract way, in order to assert the consistency with them of constitutional values in the common law. By way of example, the common law demonstrated consistency with convention rights in Articles 3, 4, and 6. In A and the Home Secretary No. 2, Lord Bingham noted that, quote, "It was clear from its very earliest days the common law of England set its face firmly against the use of torture. Its rejection of this practice was indeed hailed as a distinguishing feature of the common law," close quotes, a value reflected, of course, in Article 3 of the Convention. In Noakes and Amalgamated Doncaster Collieries, Lord Atkin emphasised the long-standing constitutional rejection of slavery, that is, the value reflected in Article 4 of the Convention, in noting that, quote, "The right to choose for himself whom he would serve constitutes the main difference between a servant and a serf," close quotes. Similarly, in relation to Article 6, it was well established in the common law that every citizen had a constitutional right of access to the court. But as the Strasbourg case law became more definite and refined over a lengthy period, it provided a determinate standard against which domestic law could be compared and potentially found wanting. Angelika Nussberger, a former president of the Strasbourg Court, has described the gradual consolidation and expansion of the court's jurisprudence from the slow start in the 1950s to what she calls the sleeping beauty slowly waking up in the 1980s, to the increasing number of cases and articulation of common values for Europe in the 1990s, to exponential growth in the court's case law in the 2000s. Counsel in the UK came to refer to the Strasbourg jurisprudence more frequently. As the UK came to lose cases in Strasbourg, increasingly a judicial sense of unease set in. Judges became conscious that their rulings might be subject to review in Strasbourg and became willing to refer to the convention to try to demonstrate that English law conformed with it. Even before the Human Rights Act, it was becoming impossible to ignore this growing and ever more specific body of law. A consciousness that the common law of obligations reflected the same values as the convention and a desire to emphasize this emerged in this way in the 1990s. In the Article 10 context of free speech, in Attorney General and Guardian newspapers number 2, Lord Gough observed that there was, quotes, no inconsistency between English law on this subject and Article 10 of the European Convention. This is scarcely surprising, since we may pride ourselves on the fact that freedom of speech has existed in this country perhaps as long as, if not longer than, it has existed in any other country in the world. The only difference is that, whereas Article 10 of the Convention, in accordance with its avowed purpose, proceeds to state a fundamental right and then to qualify it, we in this country, where everybody is free to do anything, subject only to the provisions of the law, proceed rather upon an assumption of freedom of speech and turn to our law to discover the established exceptions to it, close quotes. Similarly, in Derbyshire County Council and Times newspapers, Lord Keith reached a conclusion on the extent of a right of freedom of speech, quotes, upon the common law of England without finding any need to rely upon the European Convention, close quotes. Throughout this period, the UK courts and the Strasbourg court therefore proceeded in parallel, with the UK courts increasingly aware that the Strasbourg court was peddling fast alongside them. The continued view in the UK, however, was that since the Strasbourg court was merely interpreting and applying what were already UK values, there was little to learn or which required modification in the domestic legal system. It is relevant at this juncture to return again to the structure of the law in which constitutional values were situated. In the context of the unified common law system, without a clear substantive divide between public and private law, it was a matter of happenstance that the same values were applied in one context or the other. The common law rights which incorporated and reflected those values could, in theory, be asserted against a private individual or a public authority. However, in the latter part of the 20th century, a domestic conception of public law emerged more clearly. This had a clearer institutional home in the form of the administrative court, operating under a special procedural regime. A more specialized domestic form of what could be called droit public developed in recognition of the need to fashion legal rules appropriate for the due regulation of the expanded administrative state. As a result, a number of limitations developed from the basic propositions set out in Entick and Carrington. The law of tort was developed to give some public bodies a privileged position as compared with private individuals in some cases. In Hill and Chief Constable of West Yorkshire, a public policy limitation was spelled out to protect the police when faced with a claim of negligence in detecting and preventing serious crime, taking account of their limited resources and the danger of incentivizing them to pursue an unhelpful set of priorities in the form of overly defensive policing. This doctrine was subject to review in Strasbourg, in Osman and the United Kingdom, through the prism of convention rights. Whilst what was conceived of as a blanket immunity granted to police within the UK was held to be contrary to Article 6, the Strasbourg court rejected the complaint that there had been a breach of Article 2, the right to life, arising from the failure to protect life in that case, and in doing so referred to similar policy considerations in relation to the allocation of resources. The European form of public law thus ran in tandem with the domestic law of obligations. The other side of the coin was that, viewed in this way, unlike private individuals, public bodies were not considered to have interests of their own, nor did they have residual, unreviewable freedoms. Instead, for constitutional reasons, they had to justify their actions in terms of the public rather than their own interest. The conceptual move to recognize this dimension of constitutional values in the law of obligations had already been foreshadowed in the law relating to confidential information. Where duties of confidence arise in the public sector, they will only be upheld to the extent that they do not conflict with the public interest. This was seen in Attorney General and Jonathan Cape and Attorney General and Guardian newspapers, both of which held that lack of a public interest in the disclosure of information is a prerequisite to enforcement of a duty of confidence owed to a public body. This was the converse of the effect in Hill, where it was held that, in view of their constitutional role, it might be easier for a public body to defend itself against a private law claim. In this context, also by reason of their constitutional position, it became harder for public bodies to maintain private law claims. The drawing of distinctions in this way between public bodies and private individuals in the law of obligations tended to emphasize the growing consciousness of a new vision of how the law should accommodate constitutional values along the public-private divide, which is also coming to be regarded as central in the field of judicial review. This growing sense of differentiation of the public and the private spheres appeared to involve a significant shift of perspective. Whilst the realm of public law originated from the unified common law system, in which constitutional values were embedded, it was now coming to be seen as more distinct from public law, which appeared to be the more natural home for constitutional values. The metaphor of the horizontal dimension of private law and the vertical dimension of public law took hold. It was reinforced by the growing awareness of the European Convention, since that instrument creates rights and freedoms for individuals as against states, and thus clearly operates on the vertical model. In due course, the Human Rights Act reflected this vertical structure, since it too imposed obligations on public authorities, not individuals. The prominence of the contrast between the vertical dimension of public law and the horizontal dimension of private law gave rise to the possibility for a different way to conceive of how underlying constitutional values should be articulated and developed in the context of private law. If public law was the proper home of constitutional values, the question of the relationship between public law and private law became more acute. Should public law, conceived as a distinct source of constitutional values, have a role in projecting those values into private law in some way? The question whether public law should have this kind of radiating effect upon private law became more important with the Human Rights Act and the creation of a tabulated schedule of positive rights as part of the scheme of public law. The Human Rights Act came into force on the 2nd of October 2000. Among its important features was the imposition by Section 6 of a statutory duty on public bodies to act compatibly with convention rights. That duty applied to courts as well. The Act greatly reinforced the perception that there was an important public-private divide. Public authorities were subject to obligations which private individuals were not. Private individuals could point to a new source of rights which they could assert in disputes, although only against public authorities. There was a proliferation of human rights textbooks. They were filed in libraries in the section on public law, apart from the section on private law. The domestic and Strasbourg jurisprudence on human rights was ever more dynamic, while by comparison, private law seemed largely unchanging and in a world apart. It was in this new constitutional context and in light of an enhanced perception of the differentiation of public law and private law that a new conception of the relationship between constitutional values and the law of obligations took hold. How could human rights, applicable only against public authorities, have continued relevance to private law? The answer, derived from the Strasbourg case law, was located in the doctrine of positive obligations. Two examples will illustrate this. The first is Pla and Punkenau and Andorra, in which a testatrix in her will stipulated that property would be left to a son and that it was then to pass to a son or grandson of a lawful and canonical marriage, failing which the estate would pass to the children and grandchildren of the testatrix's daughters. The son sought to leave the inherited assets in a codicil to his wife and then to their adopted son, Anthony. The question arose as to whether the inheritance should pass to Anthony, given the terms of the original will. The Andorran court said no. Anthony and his mother successfully applied to the Strasbourg court, complaining of a breach of Articles 8 and 14 by reason of the court's decision. Notwithstanding the private law context, the Strasbourg court said, quotes, "It cannot remain passive where a national court's interpretation of a legal act appears blatantly inconsistent with the prohibition of discrimination established by Article 14, and more broadly with the principles underlying the convention," close quotes. The second case is Marx in Belgium, which concerned the status of illegitimate children in Belgium. Under Belgian law, no legal bond between an unmarried mother and her child resulted from the mere fact of birth, and the rights of an illegitimate child in relation to inheritance were also limited. Again, notwithstanding the private law context, the Strasbourg court held that the complaint was made out. Where did this conception of positive obligations come from? It's related to the approach to application of constitutional values in German law. Now, this is a very big topic, and today I can only scratch the surface of it, but I think it is relevant. I draw on the insightful account given by Cohen, Elia, and Porat in their book, Proportionality and Constitutional Culture. A key difference is that whereas English law speaks of rights, the German approach focuses more on the enunciation of values inherent in rights. This relates to different views of the state's role in relation to rights. In Germany, in order to facilitate the transformation of German society following World War II, the rights in the German Basic Law were broadly construed, assigning a major role to the state to give effect to the new humanistic values it enshrined. By contrast, the Anglo-American view of rights and constitutional values is premised on a traditional preference for state neutrality and a minimal role for the state, in which the realization of values by government may be unwelcome. The pursuit of values over rights may also reflect underlying cultural differences. A capitalist free enterprise country may be influenced by a laissez-faire liberal approach, which resists imposing limitations on the powers of the economically influential in order to protect the weaker or more vulnerable members of society, at least in the private sphere. In practice, the difference can be significant. The Anglo-American view traditionally frames rights narrowly and in negative terms. Rights are trumps used to defend an individual from the excesses of the state's power and the power of other private persons. Values are to be pursued by the state and individuals for the benefit of society as a whole. Whereas broad values may be pursued by the state, negative rights constrain the kinds of action the state can take in pursuit of those values. By contrast, in the German understanding, constitutional rights are really the vehicles for constitutional values broadly conceived. For example, the German courts have accepted the assertion of constitutional rights to ride horses in the woods or to feed pigeons in public squares. There is what has been described as a totalizing view of rights. In the case of Lueth, the Federal Constitutional Court said, quotes, "Constitutional rights are not just defensive rights of the individual against the state, but embody an objective order of values which applies to all areas of the law and which provides guidelines and impulses for the legislature, administration, and judiciary," close quotes. This constitutional view plays out in the realm of positive obligations. German law adopts a concept of Drittwirkung, meaning third-party effect. By this, it means that the constitutional values of the Basic Law have a radiating effect on all aspects of the legal system, including private law. The portal by which these rights apply in private law disputes is the obligation on courts to enforce rights, including private law rights, in a manner compliant with constitutional values. The German courts have held that constitutional rights oblige the state, including the courts themselves, to take any necessary measures in order to ensure their realization. The Strasbourg court has been subject to the influence of both the German approach to rights as the vehicles for radiating constitutional values and the English tradition of rights as negative barriers to state action. In the Marx case, the UK judge, Sir Gerald Fitzmaurice, expressed his own unease at the adoption of a totalizing conception of rights. In a strongly worded dissent, he said, quotes, it is abundantly clear, at least it is to me, and the nature of the whole background against which the idea of the European Convention was conceived bears out this view, that the main, if not indeed the sole object and intended sphere of application of Article 8 was that of what I would call the domiciliary protection of the individual. He and his family were no longer to be subjected to the 4 o'clock in the morning rat-a-tat on the door. In short, the whole gamut of fascist and communist inquisitorial practices. Article 8 was not for the regulation of the civil status of babies. At the time of the enactment of the Human Rights Act, a revolution was anticipated in relation to private law. There was much debate about the potential horizontal effect of human rights in a private law context. Under Section 6, courts were public authorities which were bound to act compatibly with the Convention rights. There was the widespread suggestion that private law rights in the common law would be constitutionalized by the importation of human rights values into the realm of private obligations. So, have the UK courts adopted a German-type view of rights? The answer is no. The UK courts have resisted the German-style approach to constitutional rights. I suggest this is for two basic reasons. First, in its application of the Convention, the Strasbourg Court has itself adopted a position part-way between the German view and the English view of rights. The Convention rights have not been given a fully totalizing effect, and the conception of positive rights is comparatively restrained. This is particularly so in light of the doctrine of the margin of appreciation, with its respect for choices made by national authorities, particularly democratic legislatures, as to how competing rights and interests should be balanced. In Belgium and Croatia, for example, concerning a private law dispute about the termination of a tenancy according to local law, the tenant's complaint based on the right to respect for their home under Article 8 was rejected. The Strasbourg Court concluded that it will accept the judgment of the domestic authorities as to what is necessary in a democratic society, unless that judgment is manifestly without reasonable foundation. The Strasbourg Court has applied a widened margin of appreciation where national authorities have been called upon to balance competing rights and interests, as is, of course, typical in a private law dispute. This tends to insulate domestic law from being found to be in violation of Convention rights, and means that the balance already struck by the law can be left undisturbed. Moreover, a double proportionality analysis may be required where Convention rights clash, such as the right of privacy under Article 8 and the right to free speech under Article 10, looking at the resolution of the dispute from both perspectives. This was referred to as the ultimate balancing test by Lord Steyn. This again has a tendency to insulate domestic law, which already seeks to balance both perspectives from any requirement for change based on the Convention rights. Secondly, and reinforcing that effect, the Supreme Court and the House of Lords before it has emphasized the way in which the common law tradition already reflected constitutional values. Where the common law could already be seen to have struck an appropriate balance between the competing rights and interests at stake, there was no need to look to other sources of rights, nor any justification to disturb that balance by reference to Convention rights. In Guardian News and Media Limited and City of Westminster Magistrates Court, Lord Toulson observed that the development of the common law did not come to an end on the passing of the Human Rights Act. Similarly, in Kennedy and Information Commissioner, Lord Mant said, since the passing of the Human Rights Act, there has too often been a tendency to see the law in areas touched on by the Convention solely in terms of the Convention rights. But the natural starting point in any dispute is to start with domestic law, and it is certainly not to focus exclusively on the Convention rights without surveying the wider common law scene. These statements were made in the public law context, but recalling the way in which constitutional values are embedded in the common law of obligations, similar points can be made in the sphere of private law. For example, in the recent case of Fern and Tate Gallery, Lord Leggett and I both regarded the attempt to rely on the right to privacy in Article 8 in a nuisance claim to be an unnecessary complication and distraction, since the common law already struck an appropriate balance between the competing rights and interests involved, leaving no space for any radiating effect of Article 8 in this area of private law. Of course, it might be said that to the extent that the common law of nuisance already sufficiently reflected interests of privacy, it did so to accommodate basic human concerns to which it gives value, rather than to make any specifically constitutional point. And that is true. But it also tells us something important about how constitutional values are embedded in the common law of obligations. They are themselves a reflection of the human values which the common law of obligations endorses and protects against others. The protection is given against others in the form of other private persons, but also in the same way against others in the form of public authorities. The common law builds out from basic human concerns, and the constitutional effects often follow indirectly as a consequence from that. So I've discussed how human rights have had a limited impact on the common law of obligations. I want to conclude, however, by saying something about the ways in which the convention rights set out in the Human Rights Act have, in fact, had an impact on private law obligations. There has been some radiating effect, despite the general resistance to this. The best example is the decision of the House of Lords in Campbell and MGN. The Mirror newspaper published photos of the model, Naomi Campbell, leaving a Narcotics Anonymous meeting with the title, "Naomi, I'm a drug addict." Ms. Campbell objected to the invasion of her privacy. She could not bring an action in defamation. There was no denying the truth of the story. She could not rely directly on her right to privacy under Article 8. The Mirror is not a public authority. Instead, she alleged that the Mirror had committed a tort by interfering with her right to privacy. She sought to develop this, by extension, from an existing tort of breach of confidence. Her submission to extend the tort was accepted. The House of Lords examined the matter through the prism of convention rights, holding that the tort needed to strike an appropriate balance between the claimant's right to privacy, Article 8, and the defendant's freedom of expression, Article 10. By conducting that balancing exercise explicitly on the basis of the constitutional values inherent in those rights, it held that Ms. Campbell's right to privacy had been tortiously interfered with. So, by what means can constitutional values continue to impact on common law obligations? Most directly, Section 6 of the Human Rights Act imposes the obligation on courts to act in a manner which is compatible with convention rights. For the reasons I have explained, that obligation has led to more modest consequences in the UK than in relation to the basic law in Germany. This portal for specified convention rights to have an effect will only therefore fall to be utilised where the common law has not considered the relevant rights and interests or has signally failed to strike the appropriate balance. But that does remain a possibility. However, there is also scope for a more indirect effect. In evaluating how the common law should develop from case to case, human rights are capable of operating as an external standard to inform and legitimate change through the development of the common law rules. Human rights may be treated as a type of a wider class of what Melvin Eisenberg calls social propositions, by which he means social standards which are capable of informing the development of the common law as it adapts to changing demands and expectations in society. I would suggest that the extension of the qualified privilege defence in the law of defamation by reference to the Article 10 case law in the case of Reynolds and Times newspapers, which preceded the coming into effect of the Human Rights Act, can be seen as an example of this. The convention rights may therefore have a more indirect legitimising role in guiding the development of the common law. This is because they reflect the values prized and protected in modern democratic society. To demonstrate its continued authority, legitimacy, and acceptability, the common law must keep pace with, reflect, and balance those values in an appropriate way. This might also be the best explanation, in fact, for Campbell and MGN. The references to human rights standards in that case may have served a purpose in unblocking a logjam in the development of the common law to recognise privacy as protectable in its own right, apart from confidentiality. So, in conclusion, I suggest that consideration of the three periods I have mentioned provides an informative perspective on the place of constitutional values in the law of obligations. Constitutional values have always been embedded within the common law of obligations. The gradual differentiation of public law and private law threatened to obscure that, and the human rights model in the European Convention and the Human Rights Act seem to offer a replacement theory based on the doctrine of positive obligations. But that doctrine is actually quite muted It does not have the totalizing effect for constitutional values, which one sees in German law. More recently, there's been a renewed appreciation of the constitutional values embedded in the common law, including as they infuse the common law of obligations. This reduces the need or justification for reliance on the doctrine of positive obligations. However, there does still remain some scope for it to apply through the portal created by Section 6 of the Human Rights Act in circumstances where the common law has signally failed to arrive at an acceptable accommodation of convention rights. And as I have said, there's also scope for human rights and constitutional values more broadly to function in limited circumstances as social propositions capable of guiding the development of the law of obligations. Thank you very much. Shall I stay here or stand next to you?
Graham is going to thank you. And then, if you'd like, it falls to Graham Virgo to thank our speaker. Just to give you advance notice, Lord Sales has very generously agreed to take questions for a period after Graham's thanks. And in fact, Graham has warned me that he may ask the first question. I'm not sure, but subject to that, you can think about questions that you might wish to ask after Graham. Thank you.
Thank you very much. I've got loads of questions, but I may make sure you have an opportunity to ask your questions of Lord Sales. I have been asked to say a few words of thanks, and I'm delighted to be able to do so. Before I do just want to say something else about the Cambridge Private Law Centre, bearing in mind I was there right at the start 10 years ago, and I just want to note my thanks to Freshfields and to the law faculty and to members of the judiciary who have been supporting the Cambridge Private Law Centre for the last 10 years. You have seen what we've accomplished over that 10-year period, and I'm sure with our new director that will continue, and there is a lot more to be done in the field of private law. But my words of thanks to Lord Sales. Pippa, in her introduction, identified the wide range of judgments that you have been involved with. I would just like to note the wide range of articles and commentaries that you have produced over many years in all sorts of fields, in tort, property law. I very recently reread your piece on tracing and exemption clauses and estoppel, and all your work on constitutional law principles and policies as well. And I think what we have heard this evening is a wonderful example of that mixing of the judicial and the academic, for which I am really grateful. We had history, we had comparative law, we had jurisprudence, and we had a lot of common sense as well in your thoughtful analysis of constitutional values and their impact and presence within the law of obligations. I have a number of things that jumped out from what you said that I think I want to take away and think further about. I think there are lessons in what you said for law schools, for this law school in particular, for law students and for academics who tend to say we are focusing either on private law or on public law, when the reality must be, as you have identified, there needs to be a melding and an identification of what happens in public law and in private law, and there is a lot to be learnt from each other. Secondly, at a time when you read newspapers and watch the television, when the language of human rights is particularly divisive, I think your calm, thoughtful, and measured analysis of human rights, the European Convention, but constitutional values and what those values are and how they can be identified within the law of obligations is very important. There is a very important message there that needs to go out widely about constitutional values and their operation within the law. But finally, I just want to say, I am sure on behalf of everybody in this room, our grateful thanks for you coming here this evening, giving your lecture. I am looking forward to reading it. There's a lot of depth there that I want to follow up. But can I ask you all to join with me in thanking Lord Sales for his lecture this evening? Thank you very much.